Here's a look at Thursday's three big rulings to reinstate his former public defenders, Bradley Rosie and Andrew Baldwin, granted, of course, to set a speedy trial date within 70 days of the High Court's decision. That was denied. And to remove Special Judge Frances Gull and replace her with another special judge. That motion, again, denied. So our question this morning, let's start with the attorneys. Was reinstating Richard Allen's attorneys the right call? We have a great power panel for you this morning. I want to welcome in criminal defense attorney and former prosecutor Michael J. Brown, law enforcement expert Sonny Slaughter, and criminal defense attorney and the host of the Defense Diaries podcast, Bob Mata. Wonderful to have you all on the program this morning. Happy Friday. All right, I'm going to begin with my attorney guests first. And Bob Mata, I want to start with you, please. As you were there, you were sitting in that courtroom, taking it all in. Talk to us, Bob. What do you think, please?
Yeah, I think it was the right call. It didn't, once it got past the procedural questions and they got into the substantive and merit issues in terms of Sixth Amendment issues, when the chief judge just flat out was citing a Supreme Court case called Gonzalez, and she recognized that it would be structural error, which is the most severe type of error that can occur during a trial. It was evident to me that they were going to be reinstating them, because essentially what that would have meant is putting the families through the nightmare of having to go through two trials, because structural error is an automatic redo. Like, so when Mark Lehman was talking about that this would be a test run trial if you don't appoint these guys who Richard Allen has selected as his private counsel, you know, it's an automatic have to retry the case. And you're talking about putting two families through the nightmare of having to relive the worst day of their lives two times. So for those reasons, I think it was the right call. And it's who Richard Allen wants to defend him. It's his life. Bob.
Yeah, that's who he wants. And I love you pointed out that was a turning point, the moment you just touched on, when he's saying it would be just kind of like a practice round going through trial number one. And you're right, that had to have hit home with those justices. And thank you for that. Michael J. Brown, to you next, please. Legally, in your opinion, is this the right call to reinstate those lawyers?
Good morning, Julie. Yeah, absolutely the right call. It was a win for the system, and really the lesson from this is don't mess with the attorney-client relationship. This defendant wanted these attorneys, although it was appointed initially. As you know, they developed that relationship and that bond and that sense of trust, and they talk about strategy, talk about the case for months and months in preparation. And for this judge to say, based on certain things that occurred, that I'm going to remove you as the attorneys, it's just dead wrong. There's other ways to deal with it, Julie. She could have sanctioned them. She could have held them in contempt. But to actually remove them as the attorneys when the defendant said, these are my attorneys, it's just simply improper. And the Indiana Supreme Court made the right decision.
I like what you said there, Michael. Don't mess with the attorney-client relationship. Leave it alone. Sonny Slaughter, I have a different question for you, please, my friend. You do consulting work for different trials, offering your expertise in the area of law enforcement. And so my question is, when you see different clients getting upset with decisions legally and all that, I'm curious your thoughts on how, and Bob touched on this, how that's just what Richard Allen wanted. His choice, he wanted those two attorneys. He was really happy with them. Your thoughts on how that might affect the litigation going forward and that relationship, as Michael pointed out, that is so critical in a criminal trial.
Right. Good morning, Julie. Good morning, everyone. It is really important when I'm working with the attorneys and interacting sometimes with their clients directly. That relationship really does matter, because then the client is providing all of the necessary information for the attorneys and for I to review. They're giving themselves freely without any reservation that they're not going to be served. And that is always in the best interest, no matter whether it's the prosecution or the defense. Everyone has a right to justice. Everyone has the right to fair and equitable justice and their ability ability to coordinate and collaborate with the team matters. So as the law enforcement person, I'm always looking at what information do we need to argue this case on the prosecution and the defense side, and the level of cooperation from the defendant is really important, so we don't have to keep doing this over again.
Very well said, Sunny Slaughter. Thank you for that. Now let's get to the stickier issue, shall we? The Honorable Fran Gull remains the case on the Delphi murders. Now, in previous court filings, Richard Allen accused Gull of violating his constitutional right to a speedy trial by pushing back the trial from January to October of this year, as well as removing Rosie and Baldwin from the case initially. So we're asking, should the Honorable Fran Gull remain on the case? Was that the right call, considering the really contentious fallout with Allen's now reinstated lawyers are all going to be back together? Let's bring back in our power panel. Bob Mata, of course, I want to start with you on this. Your thoughts, please.
It's a sticky situation, as you put it. I mean, at this point, we just want this thing to move along for the victims' families, for the administration of justice. And I don't know that it's going to be possible with Judge Gull, because there's just so much bad blood. And, you know, I mean, just remember, there is a pending motion to recuse that was filed by Rosie that needs to be heard. It's going to be addressed. If I'm Judge Gull and I've just been elected chief judge of my county, I'm sitting here thinking, like, do I need to go through this? You know, like, and just recuse herself. She's got plenty of cases to handle on her docket in Allen County, which is much, much bigger than Carroll County. And, you know, she's got the added duties of being the chief judge for a major, major county. I think if I were her, like, it's not worth the stress that I think that this trial would bring to her to sit on it. Like, it's just, at this point, I think it's too much water under the bridge. But I mean, if she's going to stay on, she's going to stay on. But if they're going to keep picking fights with each other, which I mean, she has every ability to be able to now challenge their competency by you know, giving them due process and having a hearing. I mean, we could be dealing with recusal and you know, whether or not these guys were competent in their representation of Allen for months. You know, let's just get to the trial. Let's keep working towards the trial. So I knew they weren't going to pull her, but I'm hoping she'll recuse herself.
Gotcha. Okay, Bob, fair enough. Thank you for that. Michael J. Brown, to you next. Talking about what the Supreme Court did here in Indiana, saying that legally they believe, these justices collectively, that it's the right decision to leave the Honorable Fran Gull in place. Do you agree with their legal rationale and what they did in that decision?
Julie, legally speaking, the answer is yes. Practically speaking, what's going to happen is you guys are going to get great ratings if you show this trial live, because it's going to be a back and forth. And it really is about ego from my standpoint. I think she should have recused herself. And your guess is correct. It's just going to lead down a bad path. Judges are supposed to be fair and impartial. They're not supposed to have any stake in the game. And I think because of what has transpired, it's not going to be a good look for her, and it's going to affect the trial. She should have recused herself. But in terms of the Indiana's Supreme Court's decision, I don't think there was enough there, legally speaking, to have her removed from the case.
Michael J. Brown, appreciate that. Sunny Slaughter, let's talk again about the practical aspect of this. I think we all know what it's like when you go in a courtroom, and if the judge doesn't like you, it can be a horrible experience. It can just be painful when you go to trial, when you know the judge hates you. And so these attorneys might be really in for a rough ride, huh? Talk to me about some of the practical concerns, Sunny, you may have. Let's say you were consulting with these attorneys on this case.
I would ask them to, you know, measure everything that they are doing, but also kind of think about how this trial is going to flow. I'm picking up the biases. The attorneys are going to pick up the biases, and so will the public. So they're going to have to be really strategic in how they handle, and I know that's probably not a good word, but how they handle the judge and moving forward, just to keep things going.
Right. Sonny, thank you for that. Well said. And the Honorable Fran Gull, obviously an excellent judge and very highly thought of by all of her colleagues to get this election to the chief judge position. So we'll see what happens. We'll see if she chooses to remain or chooses to recuse. We'll leave that for another day. Big thanks to you all. Bob Mata, thank you so much. Great to have you on Opening Statements. I know we've got to let you go. Have a wonderful weekend. And Michael J. Brown's going to stay with us for tipping the scales, and Sonny Slaughter's coming back when we go into Court TV Live. Here's what we've got when we come back after this break.
No, he's saying that it's on.
Oh, is it?
That's what he said. He said he think we would give a about that.